This court is now in session. You may call the file. Recognize the Honorable Justice Otera, DCJ Emeritus. I recognize Justice Tivatemwa of the Supreme Court. Thank you for coming. I recognize Justice Madrama from the Supreme Court. Thank you for coming. I recognize Justice Kasule, retired Justice of this court. Thank you for coming. The learned Solicitor General. The Solicitor General is present, yes. Distinguished members of the bar. I don't know if the Honorable, the learned DPP is present. Sorry? Okay. I'm being obstructed by a column here. We welcome in a very special way the Honorable Mr. Justice Samuel Wako Wambuzi, Chief Justice Emeritus. We also welcome Honorable Justice Monica Mugenyi, Justice of the Supreme Court and the Appellate Division of the Comesa Court. Congratulations on your appointment. Welcome. We also recognize the presence of Honorable Justice Muzamil Kibedi from the Supreme Court. Thank you for being with us. Okay. Invited guests, ladies and gentlemen, good morning. I welcome you both, all present, both in this court and online to today's special sitting, also known as the valedictory proceedings of the Court of Appeal and Constitutional Court. This is a sui generis hearing designed for court to sit in bank or in full quorum or as near to that as possible to honor one of us who is about to retire from the bench. We also will have a souvenir magazine which will be coming shortly. Today, we gather to recognize and celebrate the outstanding service of the Honorable Justice Dr. Fredick Martin Stephen Egonda Ntende, given to the law and to the wider community of Uganda and the world. We would now like to commence these proceedings. And now wish to address myself directly to the Honorable the Learned Solicitor General, who has filed a formal application for today's sitting. Learned Solicitor General, you have filed a motion in these proceedings. You may move it at this time.
Thank you, my lords. The Honorable Justices of the Court of Appeal, if it pleases the court, my name is Pius Peri Biribonwoha, the Solicitor General of the Republic of Uganda, appearing for the applicant. I appear jointly with Mr. Charles Ouma, the learned Deputy Solicitor General, Mr. Martin Mwambusia, the Director, Civil Litigation in the Attorney General's Chambers, and Mr. Richard Adrole, Commissioner heading the Department of Land and Environment, also in the Attorney General's Chambers. My lords, also at the bar, are the following: Professor Fredick Sempebwa, Senior Counsel. Mr. John Mary Mugisha, Senior Counsel. James Mukatasebugenyi, Senior Counsel. We also have Fiona Wall Navasa, Senior Counsel. The learned Deputy DPP, Lino Anguzu. Mr. Fisher Kanyemebwa. And Dr. Chirunda Robert, also present. My lords, this is an application for a special sitting of court on the retirement eminent of the Honorable Justice Fredick Egonda Ntende, Justice of the Court of Appeal and Constitutional Court, and I'm ready to proceed if it pleases the court.
So you may proceed.
Most obliged, my lords. My lords, the Justices of the Court of Appeal, this is an application made by notice of motion seeking for orders that A special sitting of court be convened to recognize and celebrate the outstanding service of the Honorable Justice Fredick Egonda Ntende as Justice of Appeal and a judicial officer in the courts of judicature upon his imminent retirement. B, that the members of the bench and bar be allowed to express their individual and collective gratitude for the service on the bench of the Honorable Justice Egonda Ntende. C, that the speeches and expressions of gratitude from colleagues, the bar, and other dignitaries be made a permanent record of the Honorable Court. D, the Honorable Court be pleased to grant any further directions and orders in connection with or incidental to this motion. And E, my lords, that no orders be made as to costs of this application. My lords, the justices of the Court of Appeal, the application is supported by the affidavit deposed by the learned Deputy Solicitor General dated 11th May 2026, in which he avers that 1. The Honorable Justice Fredick Egonda Ntende has served in various legal institutions and has held different eminent positions. 2, that the Honorable Justice Fredick Egonda Ntende was appointed by His Excellency the President of the Republic of Uganda to the position of Justice of the Court of Appeal, Constitutional Court, in May 2014. 3, that the Honorable Justice Egonda Ntende served as the Chief Justice of the Supreme Court of the Seychelles from 2009 to 2014. 4, that the Honorable Justice Egonda Ntende served as head of the Family Division of the High Court from 2008 to 2009, and that during the same period, he acted as a Justice of the Supreme Court of Uganda. 5, that the Honorable Justice Egonda Ntende served as a part-time lecturer at the Faculty of Law, Makerere University, Kampala, from 2006 to 2009. 6, that the Honorable Justice Egonda Ntende served as chairperson of the Law Reporting Committee of the Judiciary and also the head of the Commercial Court Division of the High Court of Uganda. 7, that the Honorable Justice Egonda Ntende worked as an international judge in Pec, Kosovo, under the United Nations Interim Administration in Kosovo, UNMIK, for a period of about 2 years, from November 2002 to December 2004. 8, that prior to joining the bench, the Honorable Justice Fredick Egonda Ntende was an advocate of the High Court and the distinguished Vice President of the Uganda Law Society. None that I know that he knows that the Honorable Justice Egonda Ntende served as a judge of the Court of Appeal for East Timor, which is the court of last resort in East Timor, for almost a year. During the same time, he was also working as a civil affairs officer, judicial, with the United Nations Transitional Administration in East Timor, where, together with his team, he was tasked to design, establish, and develop a judicial system of East Timor. 10, that the Honorable Justice Egonda Ntende is the chairperson of the ICMIS Steering Committee and vice chairperson of the Backlog Reduction Committee, providing policy guidance on the development of the new electronic case management and filing system, and developing a strategy to reduce case backlog for all the courts in Uganda. 11, that his integrity, professionalism, and humane approach to the law has left an indelible mark on the legal profession and the public at large. 12, that it is right and proper for this honorable court to convene and recognize and even celebrate the outstanding service of the Honorable Justice Fredick Egonda Ntende as a Justice of the Court of Appeal, Constitutional Court. My lords, it is for the aforementioned reasons that the applicant prays that this honorable court be pleased to grant the orders sought in this application. I so pray.
Thank you, learned Solicitor General. Allow me at this point to ask Mr. James Mukasa Semugenyi to support the motion.
My lords, the justices of the Court of Appeal and Constitutional Court, I rise to support the motion by the learned Solicitor General for the orders sought. I so humbly pray, my lords.
Thank you. I shall now request Dr. Robert Kirunda to rise and also support the motion on behalf of academia.
May it please the court. My lords, the justices of the Court of Appeal and of the Constitutional Court, I rise to support the motion as moved by the Solicitor General of this country and the orders sought. I so pray.
Thank you. We shall now confer and read our ruling. This is our ruling. This matter is coming up for hearing this 14th day of May, 2026, before the Honorable Justice Geoffrey Chiriabwire, Honorable Justice Cheborion Barishaki, the Honorable Lady Justice Helen Obura, the Honorable Lady Justice Irene Muliagonja, Honorable Justice Christopher Gashirabake, Honorable Lady Justice Eva Luswata, Honorable Justice Oscar Kihika, Honorable Lady Justice Margaret Tibulia, Honorable Justice Moses Kaomi Kazibwe, Honorable Justice Dr. Asa Mugenyi, Honorable Lady Justice Florence Nakachwa, Honorable Justice John Mike Musisi, Honorable Justice Biarhanga Jesse Rujema, Honorable Justice Lady Justice Esther Nambayo, Honorable Lady Justice Cornelia Kakoza Sabiti, Honorable Justice Musa Sekana, and Honorable Justice Lady Justice Stella Alibatese, Justices of the Court of Appeal, in the presence of the learned Solicitor General, for the applicant and those who have been mentioned for the respondent. We have read the notice of motion and the affidavit in support of it. We have heard the submissions of the learned Solicitor General and the concurrence of senior counsel at the bar and from academia that the motion be allowed and the orders therein granted. Now, therefore, it is hereby ordered that 1. A special sitting of this court recognize and celebrate the outstanding service of Honorable Justice Fredick Martin Stephen Egonda Ntende, Justice of the Court of Appeal of Uganda and of the Constitutional Court of Uganda upon his retirement be allowed. 2. Members of the bar and the bench are hereby allowed to express their individual and collective gratitude for the service on the bench of Honorable Justice Fredick Martin Stephen Egonda Ntende. 3. That the speeches and expressions of gratitude from the bench and the bar are hereby made a permanent record of this court. We hereby so order. As the ruling is being signed by the Justices of the Court of Appeal and Constitutional Court, we shall progress these proceedings. We shall now move to the addresses to court. Please activate the microphone in front of you when speaking and deactivate when you are finished. You are all given a maximum of 10 minutes to make a presentation. I shall now ask the Honorable Learned Solicitor General to address the court. You may do so at this moment. Thank you.
Thank you very much, my Lord. The Chief Justice Emeritus, Justice Wako Wambuzi, the Honorable, the Principal Judge, the Deputy Chief Justice Emeritus, Justices of the Supreme Court, my Lords, the Justices of the Court of Appeal, retired Justices of the Court of Appeal, Judges of the High Court, their worships, magistrates, distinguished senior counsel, colleagues in the profession, the family of the Honorable Dr. Justice Fredick Egonda Ntende, distinguished guests, ladies and gentlemen. It is both an honor and privilege to stand before you today and address you as we bid farewell to yet another towering figure in the history of our justice sector, the Honorable Justice Dr. Fredick Egonda Ntende. As we bid farewell to Honorable Justice Dr. Egonda Ntende, I am filled with admiration for the dedicated service he has rendered to our nation's judiciary since November 1991, when he joined the judiciary as a High Court judge. In his tenure on the bench, Justice Egonda Ntende served as the head of the Commercial Court between 2004 to 2008, and head of the Family Division of the High Court from 2008 to 2009. The Honorable Dr. Justice Egonda Ntende also had a stint as an acting justice of the Supreme Court of Uganda, at that time to hear appeals from the Constitutional Court between May 2008 and January 2009. The Honorable Dr. Justice Egonda Ntende, in 2014, assumed office as a Justice of the Court of Appeal and Constitutional Court, where he continues to serve until his imminent retirement. It is worth mentioning that the Honorable Justice Fredick has also served as the Chief Justice of the Seychelles between August 2009 and August 2014. As part of his illustrious international career, Justice Fredick Ntende also served in East Timor in a time in that country's most nascent phase. In all these jurisdictions, the Honorable Dr. Justice Egonda Ntende undoubtedly exported his touch of excellence and distinct Ugandan spirit. Receiving his higher and legal education in Uganda in its nascent post-independence and subsequent turbulent times must have prepared him for the days that awaited him. What is notable, however, is that in each of the jurisdictions he served in, Justice Ntende went to countries that needed his excellent services more than he actually needed them. That selfless spirit is worth emulating. During his long, illustrious career of 35 years in the judiciary, the Honorable Dr. Justice Egonda Ntende is notably celebrated for his rulings in Osotrako Limited versus the Attorney General, Major General David Tinyefunza versus the Attorney General, and the Attorney General versus Susan Chigula, to mention but a few. I should say that the Honorable Justice Egonda Ntende has demonstrated unwavering commitment to upholding the rule of law, protecting the rights of the vulnerable, and promoting justice for all. His contributions to our country's jurisprudence are immeasurable and have impacted on the lives of countless individuals and communities. As a jurist, the Honorable Justice Egonda Ntende has been a shining example of fairness, impartiality, and wisdom. His judgments have been meticulous, well-reasoned, and guided by a deep understanding of the law. His commitment to justice has surely inspired a generation of lawyers and indeed judges. The Honorable Dr. Justice Egonda Ntende also made an invaluable contribution towards improving the administration of justice in Uganda. In 2016, he was appointed Vice Chairperson of the Backlog Reduction Committee, a position he holds to date. He has been tasked to develop strategies to reduce case backlog in the judiciary. In addition, the Honorable Justice Egonda Ntende was appointed a chairperson of the Electronic Court Case Management Information System, ICMIS, steering committee, where he is providing policy guidance on the development of a new ICMIS system for all of the courts. Consequently, as he prepares to retire, he will leave behind a legacy of excellence, integrity, and a dedication to transformative impact that will continue to inspire the generations to come. So as we celebrate his remarkable career, we also honor all his personal attributes that enabled him to perform his work with diligence and integrity. The Honorable Dr. Justice Egonda Ntende has indeed been a beacon of inspiration to us all, and his presence will certainly be missed. But beyond his formidable legal mind, the Honorable Dr. Justice Egonda Ntende was a part-time lecturer at the Faculty of Law, Makerere University, where he imparted knowledge on computers and the law to law students between 2006 and 2009. To the Honorable Dr. Justice Egonda Ntende, as we embark on your journey out of service, we would like to reassure you that your work endures. The precedents you have set, the principles you have upheld, the lives you have touched and transformed will resonate for many years to come and will be the foundation for the future of Uganda in the realms of public and judicial service. While we shall miss your presence in the temples of justice, we take solace in the knowledge that your commitment to justice will continue in new forms outside the judicial system. On behalf of the bar and a grateful nation, I reiterate our appreciation for your service. I join all gathered here today to celebrate your legacy and wish you all the joy and fulfillment that retirement can bring. We express our gratitude to your loving family that has supported you on this long and fruitful career. We are gratified that your son is now a member of the bar, and we are confident he will carry on the legacy you have left with us. As we embark on this new chapter in your life, we wish you joy, peace, and fulfillment. May your retirement be filled with love, laughter, and the knowledge that your legacy will continue to inspire and guide us. Please join me in expressing our heartfelt gratitude to the Honorable Dr. Justice Egonda Ntende for his exceptional service, his unwavering commitment to justice, and his enduring impact on our nation. Most obliged.
I thank the learned Solicitor General for his address. I shall now ask the learned Director of Public Prosecutions, Mr. Lino Anguzu, to address the court.
May it please the court, my lord, justices of the appeal, the principal judge, my lord, DCJ Emeritus, and retired judges present. Your lordships who joined us this morning, my colleagues at the bar, ladies and gentlemen. Today, this court sits not merely to mark the retirement of a judicial officer. It sits to honor a towering institutional mind, a fearless defender of liberty, an uncompromising guardian of legality, and one of the most consequential jurists ever to serve the Republic of Uganda and the wider Commonwealth judicial community. We gather to celebrate Honorable Justice Fredick M.S. Egonda Ntende, a judge whose jurisprudence transformed constitutional governance, enriched criminal justice administration, deepened prosecutorial accountability, and restored faith in the idea that courts exist not for power, but for justice. Justice Egonda Ntende belongs to that rare generation of judges who understood that law without humanity becomes oppression, and that constitutionalism without courage becomes ceremonial rhetoric. Throughout his illustrious judicial career, he demonstrated consistently that the Constitution is not a dormant political document to be admired from a distance, but a living charter of liberty, demanding daily protection through fearless adjudication. For the prosecutors in this country, his jurisprudence has been both a compass and also a conscience. Justice Ntende fundamentally shaped the philosophy of prosecution in Uganda. He reminded us that the role of the prosecutor is not merely to secure convictions, but to defend legality, fairness, constitutionalism, and public confidence in justice itself. His decisions, my lords, repeatedly taught that criminal prosecution derives legitimacy from severity, not from severity alone, but from fidelity to due process, dignity, and the rule of law. He demonstrated this in a number of decisions, one of which, my lords, was in the case of Shabahura Matia versus Uganda, criminal revision case number MSK Massacre 0005 of 1999. He affirmed that court processes possesses inherent jurisdiction to prevent abuse of process and to stop prosecutions that become oppressive through delay. He identified the factors relevant in determining whether delay becomes unconstitutional, namely the length of delay, reasons for delay, conduct of the state, institutional inefficiencies, prejudice suffered by the accused, and whether the prosecution process itself had degenerated into oppression. He ultimately held that unexplained 4-year delay violated an applicant's right to a fair and speedy trial and constituted abuse of court process. Accordingly, he stayed the prosecution. My lords, That decision fundamentally altered prosecutorial consciousness in Uganda. It established that criminal prosecution cannot become indefinite institutional punishment before trial. It compelled prosecutors to confront delay not merely as an administrative inconvenience, but as a constitutional injury capable of nullifying otherwise lawful proceedings. My lords, these principles were followed years later and resonated in the case of Bonifacio, Muluga, and others against Attorney General, Constitutional Petition number 17 of 2015, and others. Justice Egonda Ntende, his influence upon the prosecutorial ethics became even more profound in the case of Paul Wanyoto Mugoya versus Ouma Joshua and Attorney General, Civil Appeal number 91 of 2021, where the Court of Appeal, my lords, condemned torture and unlawful investigative methods in words that permanently reshaped human rights jurisprudence within criminal prosecutions. Justice Egonda recognized that torture is often committed in secrecy and may leave no visible marks. He questioned how victims subjected to clandestine brutality could reasonably be expected to produce photographs, medical reports, or conventional forms of evidence. Most importantly, he affirmed that courts possess an affirmative constitutional obligation to hold prosecutions tainted by violations of non-derogable rights. My lords, in principle, we hold different views on these declarations, but his jurisprudence in that case decisively strengthened prosecutorial obligations to reject evidence obtained through torture and coercion or abuse. Today, because of Justice Egonda Ntende's contribution and his jurisprudence, prosecutors in Uganda approach human rights compliance with far greater seriousness than before. His decisions elevated prosecutorial standards beyond technical proof towards constitutional legitimacy itself. He taught us that a conviction secured through abuse weakens justice rather than strengthen it. My lords, Justice Egonda Ntende also profoundly influenced Uganda's bail jurisprudence. At a time when pretrial detention increasingly risks becoming normalized, he courageously defended the constitutional presumption of innocence and warned against hostility towards bail rights. He has repeatedly reminded courts that liberty is the constitutional norm and detention the exception. He criticized what he termed as flimsy reasoning used to deny bail and challenged mechanical remand practices that reduce liberty to administrative convenience. His jurisprudence restored constitutional discipline to pretrial justice and reminded prosecutors that opposition to bail must always remain principled, evidence-based, and constitutionally justified. My lords, despite all this, Justice Egonda Ntende was never an absolutist defender of accused persons at the expense of victims or society. On the contrary, his criminal jurisprudence demonstrates a careful balance between liberty and accountability, mercy and deterrence, fairness and public protection. In numerous appeals involving murder, aggravated robbery, defilement, corruption, and violent crime, he firmly upheld convictions where evidence proved guilt beyond reasonable doubt, and endorsed severe punishment where circumstances demanded societal denunciation. His sentencing jurisprudence has reflected deep judicial wisdom. He understood that punishment must not become vengeance, but neither should it become indifference to suffering inflicted upon victims and communities. My lords, Justice Egonda Ntende's contributions also extended profoundly into constitutional governance and judicial independence in landmark constitutional petitions election disputes, and human rights matters, he consistently defended constitutional restraint, legality, accountability, and separation of powers. His influence, my lords, extended beyond our borders of Uganda. As Chief Justice of Seychelles, he became internationally respected for strengthening judicial independence, promoting constitutional accountability, and advancing the rule of law reforms within a small but strategically significant constitutional democracy. In East Timor, a nation emerging from conflict and institutional fragility, he contributed to rebuilding judicial credibility and strengthening post-conflict constitutional justice. Across jurisdictions, he carried with him an unmistakable judicial philosophy grounded in courage, fairness, dignity, and institutional integrity. My lords, for the prosecutors specifically, his legacy has transformed institutional practices in multiple ways. Because of Justice Egonda and Ntende, my lords, my lord, may I have another 2 minutes to conclude?
Granted.
Most obliged. One, my lords, because of Justice Egonda and Ntende's jurisprudence, prosecutors are more conscious of constitutional timelines and delay management. Human rights compliance during investigations is taken far more seriously. Evidence obtained through torture and abuse faces greater scrutiny. Sentencing submissions are approached with deeper appreciation of proportionality and fairness. Bail opposition is increasingly expected to be principled and evidence-based. State accountability within the criminal justice system has become significantly stronger. Victims' rights are increasingly recognized within broader constitutional justice. Institutional professionalism within prosecution has substantially improved, but most importantly, he taught prosecutors that justice is not measured solely by convictions secured, but by integrity with which prosecutions are conducted. My lords, your lordships and distinguished guests, great judges do more than decide cases. They shape national conscience. They redefine institutional culture. They enlarge constitutional imagination. They leave behind principles that outlive generations. By that measure, Honorable Justice Fredick Egonda Ntende stands among the great institutional jurists of our time. His decisions will continue to guide prosecutors, judges, scholars, investigators, and future generations of lawyers long after this ceremonial sitting concludes, my lords. His legacy will endure in every courtroom where liberty is defended against oppression, where fairness prevails over expedience, where constitutionalism restrains abuse of power, and where justice remains anchored in humanity. On behalf of the Office of the Director of Public Prosecutions, my lords, I express profound gratitude for his extraordinary service to Uganda, to constitutional justice, to the Commonwealth legal tradition, and to humanity itself. May his retirement be peaceful, fulfilling, and richly deserved. And may future generations continue to breathe life into the Constitution just as he so courageously did throughout his remarkable judicial life. I thank you, my lords, and I beg to submit. Thank you.
I thank the learned Director of Public Prosecution for his address to court. May I now ask Mr. James Mukasa Sebugenyi, Senior Counsel, to address the court.
My lords, the justices of the Court of Appeal and Constitutional Court, the justices of the Supreme Court, distinguished members of the bar, senior counsel present, your worships, ladies and gentlemen, all protocol observed, and I stand on the protocol which has been laid by the presiding judge. My lords, I am humbled and privileged to have been given this opportunity to present on behalf of the members of the bar My lords, I was told I have 5 minutes. Here it says 10 minutes, but that document I left behind was for 30 minutes. So, but I will fit in the 6 minutes, my lords, with your permission. Like I've said, it's great to witness this occasion. Honorable Justice Fredick Martin Stephen Egonda Ntende, Chief Justice Emeritus, born in 1956, a son of Makoka, Kamuli, Busoga, a product of Mwiri schools. Unfortunately, you didn't go to Budo. Is one of Uganda's most respected jurists and a major figure in law, governance, judicial reform, and transformation. In 2024, you were awarded a Doctor of Laws honoris causa by Makerere University. A former Chief Justice of Seychelles, 2009-2014, hence the title Chief Justice Emeritus, and deservedly so. International Judge, UN Mission in Kosovo, 2002-2004. My lords, I could go on and on, but I just want to stand and associate myself with the very eloquent presentations which have been made by the learned Solicitor General and the learned DPP. And I associate myself with all that, and I will jump those aspects of your accolades and things you have done. In this special sitting, we affirm your legacy of a superb journey and good example. My lords and all present here, in life you can be a good example or a horrible warning. My Lord, Justice Egonda Ntende, you are a good example. I asked a wise man, just like Justice Egonda Ntende, tell me, sir, in which field could I make a good career? And he said with a smile, be a good human being. There is a lot of opportunity in this area and very little competition. Chief Justice Emeritus Egonda Ntende, you have been a good human being in your career and life. You have discharged your judicial and civil duties in an exemplary manner. You have, with obedience, abided by the laws of many states and nations where you've had a chance to reside. You have never lost sight of the allegiance due to the sovereign of your native land, Uganda. You have practiced 4 cardinal virtues, which us, the members of the bar, appreciate. 1, temperance. 2, fortitude. 3, prudence. But last but not least, justice. My Lord, merit has been your title to the various honors and favors. And on you, these favors have not been undeservedly bestowed. As a Lumumbist elephant, I repeat, us Lumumbists and elephants are proud to say we are Lumumbists, and I'm proud to be one. Grit, perseverance, resilience, strength, and determination you have with your honor displayed. Like an elephant, you have exceptionally long-standing memory, remembering details, events, and people way back, and you don't easily forget. I have witnessed this in the many speeches and presentations you have made. These traits of a Lumumbist elephant have manifested themselves in your judicial service tour, putting justice before fear and favor. Integrity. This has earned you respect and opened doors for other Ugandan jurists and judges internationally. You have used the Constitution to fix unfair laws, to protect the weak, and to hold the powerful accountable. You have made strong rulings and judgments against torture, unlawful detention, abuse of power, to mention but a few. Because of time, I cannot detail all of them. Allow me to make a few quotes from the platforms of some members of the bar. Just 2. It is nearly impossible to speak of any serving judicial officer with the esteem reserved for Justice Egonda Ntende. Justice Egonda Ntende, a man of unmatched integrity, fearless independence, and rare intellectual depth. My lords and members here present, let us talk about jurisprudential temperament. My lords, we all agree we boil at different temperatures. Some judges stretch the law, and others are constrained to hold. Courts, as an instrument of society, are designed to reflect in their decisions the morality of the community, to look precedent in the teeth, and to measure it against the ideals and aspirations of the times. My Lord Justice Egonda Ntende, you have done your part in this aspect. To us in the legal profession and legal practice, particularly us who are this side of the bar and the bench, the advice to peers, juniors, and associates appearing before you has been, make sure your legal argument is sound, convincing, and concise if appearing before Justice Egonda Ntende. Do not dilute it or pollute it with briefs or your brief with superfluous contention. An example I can give, asking a doctor in cross-examination, how many postmortems have you done on dead people? And then the answer is, from the doctor, all my postmortems are on dead people. My lords, in conclusion, to all present as we talk about Justice Egonda Ntende, Chief Justice Emeritus, what is your blueprint? Martin Luther King asked this question on 26 October 1967. Be the best of whatever you are. You have been the best at your job as a judge. We appreciate it. What is your legacy? What will you be remembered for? Justice Egonda Ntende, yours is a tell story of worth, legacy, and a worthy example, and a good blueprint. You are within eyesight of your retirement after 35 years of judicial service since 16th November 1991. As you head into the sunset of your life, know that you have fulfilled God's plan and purpose of your life. Your divine assignment, I repeat, your divine assignment has come to an end with excellence and a legacy. You have fulfilled your life blueprint. You have made us proud. A hero and a coward both have feel the same thing. It is what they do that makes a difference. It is what the hero does that makes him a hero, and what a coward does not do that makes him a coward, him or her a coward. What we feel is not going to leave a legacy. What we do or don't do will. You have done your part, Chief Justice Emeritus Egonda Ntende. To the family of Justice Egonda Ntende present, we want to thank you. We don't take you for granted for the support you have given him. Retire in peace, my friend and hero. Distinguished members of the bar, excluding judges, your worships, and the rest of you, upstanding, please. All lawyers except Solicitor General, upstanding, please. And let's give him one last bow. Thank you.
I thank Mr. James Mukasa Semugenyi, Senior Counsel, for your address to court. I will now ask Dr. Robert Kirunda to speak on behalf of academia.
My lords, the Justices of Appeal, my lords, the retired Chief Justice Wako Wambuzi, Deputy Chief Justice, Richard Butera, my Lords Justice of the Supreme Court present, my Lords Judges of the High Court, Your Worships, colleagues at the bar, senior counsel especially, the Solicitor General, and my colleagues from the Ministry of Justice, distinguished ladies and gentlemen, may I start where I should have ended, first by thanking most sincerely the family of Justice Dr. Fredick Martin Stevens Egonda Ntende for being here today. It is my unmitigated honor to join this court in celebrating one of Uganda's most distinguished jurists. And I will start on a personal note. I first met the Honorable Justice Dr. Egonda Ntende in 2003. I was a fourth-year student planning my thesis on Article 126(2)(e at a time when the jurisprudence of this court was still unsettled. I asked the good judge for his views. He called my attention to the double negative in that article and invited me to inquire into whether the framing of the wording of that article was affecting the court's interpretation. I was awestruck. I asked him one more question that evening. What does it take to succeed in private practice? Without pause, he gave me a one-word answer that has guided my practice in all my years at the bar. Prepare. Every day I see lawyers come to my court with the best cases, but they are unprepared. Do you know what I do? I dismiss. Doesn't matter whether you are for the plaintiff or for the defendant. I would live to feel the weight of that counsel in April 2009 when I appeared before Justice Dr. Ntende in Kazora v. Kazora. I had spent 3 days on the main suit. I felt ready, but the court had called an application, not the main suit. I had no instructions in that application. I protested. Step out, take instructions, you have 5 minutes. We stepped out. My clients had forgotten what this application was about or who had drafted it. You see, the matter had become so convoluted. I was plaintiff's counsel number 7, and they didn't even remember which lawyer had drafted the application this judge was talking about. 5 minutes later, I walked back into the court to appear before a judge famous for never granting adjournments, and you can imagine what happens after that. When he delivered his ruling that morning, every word in that decision was in my client's favor, except the last 2 words. Application dismissed. In the years that followed, I have done my best, my Lord, to never appear in a court unprepared. From that beginning to this day, Justice Ntende's life has taught us 3 enduring lessons among the many that my colleagues have enumerated and which I associate myself with fully. First, one can rise from any humble background to the highest possible realms in society. Through the story of the son of a teacher from Makoka to Namwendwa to Muiri to the Chief Justiceship in Seychelles, with consequential stops in East Timor and Kosovo along the way before arriving at this court, Justice Dr. Ntende's trajectory is a standing rebuke to the idea that origin determines destination. Second, one can live with integrity and have undeniable impact even within systems that don't make it easy. As my colleagues at the School of Law have noted, and the Dean is here, I will just point out, my Lords, Professor Nalwairo is the Dean of Law. My colleagues at the School of Law have noted in a special sitting of the board that the intended doctrine, and it is fair to call it that, spans across constitutional law, civil procedure, contract law, family law, criminal law, human rights, and international law. In Osotrako, he swept away the age-old barriers to remedies against government. In Katovi Njuki, he struck down a discriminatory colonial-era provision barring Africans from the High Court in divorce matters. In Abuki, he held that the constitutional right to life includes the right to livelihood. In Tinyefuza, he held that national objectives and directives principles are interpretative guides to the Constitution, and that legacy has endured. In Re Nicholas Mwanja, he called for adoption reform that eventually found its way in the Children's Act of 2016. In Susan Chigula, Justice Dr. Ntende charted a pragmatic path for the integration of international legal norms into a national framework. In Ogwang and Damaro in the Constitutional Court, his fidelity to civil liberties is so unambiguous that in the latter decision, he personally invited citizens to challenge human rights abusers in their individual capacities. That, my lords, is a body of work. That is a legacy. Thirdly, One does not need high office to have earth-shattering impact. Justice Dr. Ntende was a substantive member of the High Court when he wrote his famed decisions in Tinyefuza and in Chigula. High office would follow, as it does follow, to those who do their duty where they stand. When I once asked him why he returned so early from Seychelles, where his impact was so undeniable, his answer was as simple as it was profound. Our duty in life is to do our part and leave the stage in time for others to judge our contribution, preferably while we are still alive. As a public servant, his record as the head of the Commercial Court, the Family Division, and ultimately Chief Justice of Seychelles before arriving at this court is really noted and exceptional. As in one of her speeches, his successor described a judiciary in Seychelles that is now transformed. New premises, modern case management, international partnerships, and a strategic plan whose fruits outlasted his tenure. His gift, in his successor's words, was harnessing public resources, attention to detail, and a stubborn ability to steer the course straight ahead. For his excellent jurisprudence and enviable administrative work, some members of the bar believe that Justice Dr. Ntende is a Chief Justice Uganda never had. I will leave that thought where it rests. What I know is that he retires a contented man, a man of deep faith who has never been shy to quote scripture from the bench. Perhaps it is from that rich repository of faith that he draws his contentment. The Bible does say, godliness with contentment is great gain. We are grateful, my Lord, for the jurisprudence, for the life lessons, for the transformative leadership across every station you've served. We are grateful to your family, who endured long absences, political tensions in fragile democracies, and the quiet sacrifice that judicial office demands of those who love the one who holds it. It was an honor and a privilege to appear before you, my Lord. We at the bar will remember you as a judge before whom one was certain that in your court, the law was never a suggestion to some or a toy for others to trifle with at will. Certain that if one did their part to prepare, they would have a good day in court. Certain that you would respect members of the bar regardless of their age or years of call. When you stood as an officer of the court in Dr. Ntende's court and carried yourself as such, you would be fine. My Lord, you were fair to all that appeared before you and to those who would suffer the consequences of your decision. We will remember you as a judge who embodied the judicial oath in its truest sense, who acted justly, loved mercy, and walked humbly with your God. For your fidelity to the law and the cause of justice, and for all your years of labor, may God reward you richly for your distinguished service. May the lessons you have taught us through your quiet, gentle, disciplined, studious, and efficient life endure in us, and may God grant us the grace to pass them along. I leave you, my Lord, with the words of Hebrews chapter 6 and verse 10. For God is not unjust. He will not forget your labor of love, how hard you have worked for him, and how you have shown his love to those that you have cared for. I wish you a joy-filled retirement, a restful time. The bar will miss you, and may you enjoy only heaven's choicest blessings. May it please the court.
I thank Dr. Robert Kirunda for his address to court. I want to recognize the presence of Honorable Lady Justice Catherine Bamugemerere from the Supreme Court of Uganda. Thank you for being with us. And I know we have very many, but because of time, let me just also recognize the presence of very many High Court judges who are with us. My lords, we are humbled at your presence. As presiding judge, I have received a request, and I know we just have a little bit of time, from the Honorable Mr. Justice Madrama Christopher to say something. Is that correct, sir, my lord?
Well, I made a request. I wondered whether there were slots, but the time will determine whether it's possible.
We had one more speech which has not taken place. We will grant you.
Go ahead with the speech.
Okay.
Well,
You have been given the opportunity.
thank you. Thank you, Honorable Justices of the Court of Appeal, my Lord, the Honorable Justice Wako Wambuzi, Chief Justice Emeritus, my Lord Justice Butera, adopt the protocol as laid down by the Honorable members of the bar. I would like to say that the retirement of Justice Egonda Ntende marks the conclusion of a singular chapter within our national legal history. However, as we gather today in the year 2026 to celebrate my esteemed brother, Justice Fredick Martin Stephen Egonda Ntende, upon his retirement from the Court of Appeal of Uganda, we are not merely closing a chapter, we are witnessing the transition of a figure whose influence has truly been global, multidimensional, and structurally transformative. Over a majestic career spanning 4 decades, my brother Justice Egonda Ntende has held many vital roles. He has been a private advocate, a domestic judge, an international adjudicator, a post-conflict zones adjudicator in a post-conflict zone, a chief justice of a sovereign island nation, our nation's foremost pioneer of digital justice. His legacy is defined not merely by the volume of his judgments, but by the unwavering fealty to the cause of justice and an utmost incorruptibility that was rightfully earned him recognition as one of the most sophisticated legal minds in East Africa and beyond. To truly comprehend the impact of my brother Justice Egonda Ntende on the modern judiciary, we must look back to his formative years and the intellectual genesis of a reformer. Born in Uganda in 1956, I will not give that part because it has been ably summarized by previous speakers. I would like to say that the defining characteristics of his intellectual trajectory was his remarkable foresight. In the 1990s, at a time when many peers were specializing in traditional branches of law, such as commercial litigation or criminal procedure, Justice Egonda Ntende pursued a Master's of Law in Information Technology and Telecommunications Law from the University of Strathclyde in Glasgow. He anticipated the imminent intersection of digital revolution and administration of justice, an early academic interest that would ultimately allow him to lead our judiciary from a paper-based system to the digital frontier of the 21st century. When my brother was appointed a judge of the High Court in 1991, he brought with him a jurisprudence of liberty. His judicial philosophy was immediately marked by a purposeful approach. He viewed the law not as a static set of rules, but as a living instrument for the protection of fundamental rights and the promotion of a just, free, and democratic society. His impact was subsequently felt across constitutional, contract, family, and international law. Many remarks were made about some of his extensive rulings, and I'll skip that. His career is unique among us for its sweeping international dimension. He is a global jurist described frequently as a development practitioner who specializes in revitalizing dysfunctional judicial institutions in some of the world's most difficult post-conflict environments. And you have heard his work in East Timor, panels for serious crimes, the hybrid of tribunal created by the UN Transitional Administration, and many other. The trial of 55 trials involved, resulting in 84 convictions. His appellate role ensured these sensitive early trials met international standards of due process, legitimizing the new nation's legal framework. You also heard about his mission in Kosovo, UNMIK. I'll not say much about that. Now, his international transformative leadership reached its zenith when he served as Chief Justice of the Supreme Court of Seychelles from 2009 to
14, inheriting a judiciary suffering from a profound crisis of public confidence, he found a system that was slow, understaffed, and potentially susceptible to external influence. He initiated a comprehensive mandate of judicial and business reform, boldly reminding judicial staff that they are servants of the people and not their masters. He bluntly diagnosed the system's failures in a 10-year absence of court reports, 8-month delays for transcriptions, and technology belonging to the 19th century. His structurally deep reforms turned the tide. He tackled backlog management by introducing strict service and time standards, enlisting the Commonwealth Secretariat to provide judges specifically to clear delayed cases. He modernized infrastructure by overseeing the 2013 opening of the Palais de Justice. I wonder whether the French is correct, replacing the Palais de Justice, replacing manual recording with digital courtroom technologies to fundamentally increase productivity. Spearheading the legal transparency, he consolidated the nation's laws into an electronic portal known as the Seychelles Legal Information Institute, that is CELI, like ULI, which we have also benefited from in our jurisdiction. I wanted specifically to focus on his transformative work in digital and e-justice, and from the genesis of our own Uganda Legal Information Institute, ULI, democratizing legal information by providing free and unrestricted online access to primary court decisions to both practitioners and the public. This lifelong passion culminated in his role as chairperson of the steering committee of the Electronic Court Case Management Information System, ECMIS, officially launched in March 2022. He was the primary intellectual driver, moving us from the paper dockets to digital files, completely eradicating the chronic issues of lost files and delayed proceedings. The features and strategic benefits of the ECMIS framework he championed was monumental. He introduced electronic filing, allowing cases to be filed remotely via a secure portal, reducing physical congestion and administrative delays. He integrated automatic notifications, providing SMS and email alerts for summons and hearing dates, significantly improving court attendance and reducing no-show adjournments. And there's more to say about his role in the digital realm. During the implementation of ECMIS, his pragmatic and hands-on leadership was constantly evident. In review meetings 2022, he urged us to fast-track payment integrations with the Bank of Uganda and fearlessly addressed granular issues such as system search functionality and the lack of comment boxes for registrars. He demanded that we view trial phase challenges as vital for progressive success, calling on all judicial officers to own up the innovation. To us, the legal fraternity, Justice Egonda Ntende is the jurist. You simply cannot step into his courtroom unprepared. You must be ready for the hearing. His opinions reflect a deep philosophical appreciation for the law and its historical trajectory. Some peers have rightly expressed that his unrivaled integrity and brilliance may have made him an unsung hero, noting that higher judicial officers in the Supreme Court occasionally eluded him despite his obvious qualifications. Yet beneath his rigorous standard lies a gentleman with a calm and thoughtful demeanor. During a quarterly luncheon at his residence in Jinja, March 2026, he was universally described as a peacemaker, even in difficult moments, and a gentleman who warmly supports and welcomes others. Justice Jiborin Barishaki praised his role in fostering true collegiality in our appellate bench, helping to build a supportive environment for officers facing heavy workloads. Our court administrator, Justice Geoffrey Kirabwire, accurately noted that The Court of Appeal will continue to draw upon his brother's experience and wisdom well into his retirement. As he reaches the constitutional age limit of 70 years, a milestone requiring his vacation of office, this year we look into the final personal chapter of his journey. At that poignant luncheon, he shared the history of his residence in Jinja City. He acquired a plot in 1992 with specific intention of building his retirement home. While construction was delayed for years by his international service with the United Nations, for the past 12 years, he steadfastly commuted from his home to his duties in Kampala. His retirement will now allow him to focus on his family enterprise, Riverside Farm. The pure honey he produced and shared serves as a beautiful symbol of his transition to private life, reflecting a groundedness in agriculture and family that has particularly balanced his high-level international career. It was entirely fitting that in early 2024, his alma mater, Makerere University, conferred upon him an honorary Doctor of Laws. The University Council recognized that he had demonstrated exceptional accomplishments in upholding ethical principles and the development of the judicial system in Uganda and globally. It was a powerful validation of 40 years of service above self. It was, I'm summarizing, my lord. If we are to summarize his incredible career, achievements, and recognition, we can look to his pristine integrity, universally acknowledged for his utmost incorruptibility and unrivaled integrity. We look to his jurisprudence defined by landmark rulings in constitutional and property law like Osetrako and Tinyefuza. We look to his international impact, having served as Chief Justice of Seychelles and a UN judge in Kosovo and East Timor. We look to his technological footprint, having founded ULI and chaired the ECMI Steering Committee, and we look to his honors beautifully capped by his honorary Doctor of Law from Makerere University. My lords, Justice Fredick, Martin, Stephen Egonda Ntende is a figure who defies simple categorization. He is a local advocate from Jinja who became a global authority on international criminal law. He is a traditional jurist who mastered the complexities of telecommunications law. He is a reformer who redeemed the judiciary of two different nations. His magnificent legal legacy rests on three pillars. First, his intellectual depth. His judgments are not just legal decisions. They are masterpieces of constitutional reasoning and will be studied by law students for generations. Second, his structural reform from the Palace, the justice in Seychelles, to the ECMI system in Uganda. He has built a physical and digital infrastructure of modern justice. Third, his ethical example. In an area where judicial independence is often under threat, he has remained true to the highest creed of humanity, practicing with humility and fealty to his oath, and made him a beacon for the entire profession. As the Court of Appeal prepares for his formal send-off, the words of his peers provide the most fitting summary of this impact. He is a calm and thoughtful colleague, a peacemaker, and a gentleman who has set the bar very high. His retirement is not just the end of a career, it is the celebration of a life spent in the relentless pursuit of justice, equality, and the rule of law. My brother, the pure honey of your retirement is wonderfully well earned, following a life of service that has left the judicial world significantly sweeter, fairer, and infinitely more efficient than you found it.
I thank the Honorable Justice Christopher Madrama, Justice of the Supreme Court, for his address to the court. For those of you who are familiar with our protocol, this court is incapable and lacks jurisdiction to overrule any direction that comes from the Supreme Court. I shall now move to the bench and ask the Honorable Mr. Justice Boni Cheborion Barishaki to address the court.
Thank you. Thank you, Presiding Judge. My Lord Justice Wakwambuzi, Chief Justice Emeritus. My Lord Justice Butera, Deputy Chief Justice Emeritus. I saw the Principal Judge around. My Lords, the Justices of the Supreme Court present and judges, the bar, and distinguished ladies and gentlemen. I was asked to speak as a colleague to Justice Fredick, Martin Stephen, Egonda, and Ntende. As you have all heard, a lot has been said. When I was looking at my short script, I didn't see anything that has not been said. The detail to which Justice Madrama has gone, I think has made it very easy for me. I'll just say a few words from this side. It is an honor to me to speak on this occasion when we honor one of us for a good job well done. I first heard about Fredick Martin Stephen Egonda Ntende as a practicing advocate and a vice president of the Uganda Law Society when I was a state attorney in the Attorney General's chambers. I later came to know him more when he became a judge of the High Court, but became more close to him when I joined the Court of Appeal, where we worked collegially and in teams. We traveled, stayed together, and worked very closely during sessions outside Kampala, because that is the time when we could sit together after the court hearings. During all this time, I came to know him as a person with profound respect, not only for himself, but more so for others. He respected other people's views and opinions and was never dismissive, even for the weakest of arguments put to him. His response, though sometimes very strongly put, was never with a raised voice. For all the time we worked together, I never heard the words, "That is rubbish, useless, sit down, keep quiet," from him. He always dealt with matters in a principled manner, with enduring commitment, and speaking through well-structured, concise, and consistent judgments. We would at times have arguments on the length of sentences, especially in murder cases, where he pivoted around 20 years, when some of us would be going for 30 years and sometimes beyond. Though senior, he would take the dissents with a lot of humility. My Lord, Justice Egonda, your tenure at the bench has been a legacy of development of jurisprudence, as has been said by many. You have clarified complex legal issues, and your decisions will continue to guide access to justice in this country and beyond. It was no surprise to us who work with you when the academia recognized this attribute and made a Scholar Award to you. One of the biggest achievements the Uganda's judiciary has attained is the access to justice through the setting up of the Electronic Court Case Management Information System, commonly known as ECMIS. Justice Egonda Ntende, as has been said, was very instrumental in its setup. Now we judges no longer require vans to carry files when we go up country for sessions, because all the files are now in the system and in our laptops, which are accessible anytime, anywhere. Lawyers need not move out of their offices to file cases or other court documents, for they now do it in the comfort of their offices. And lawyers need not now hire pickups to carry files and books to court, as has been in the past. Indeed, life has been made very easy for for legal practitioners. Thank you, my brother, for your selfless contribution in this regard. Finally, I want to thank you for the humility with which you have conducted yourself. I dare say it should be an example to many of us. I remember when you invited us for lunch at your Ginger home, you waited at the entrance of the house for each of us to arrive and personally escorted each one of us to their seat. When I was asked to say a word after the sumptuous meal served by your dear wife, Margaret, and several glasses of grape juice, I made a joke that your service as Chief Justice of Seychelles and an international judge in Kosovo and East Timor had made you a diplomat par excellence. In my view, and as Kirunda said, you are the Chief Justice Uganda has never had, but whom we deserved to have had. I thank your family for the support it rendered to you all this time. As you retire from active service, we at the Court of Appeal will miss your wise counsel and the leadership skills, but we believe that you will undoubtedly continue to guide our people from wherever you will be based. I and my colleagues here extend our deepest appreciation for your distinguished service. We wish you good health and fulfillment in the years to come. I thank you. I'm pressing.
I thank the Honorable Justice Boni Cheborian Barishaki for his address. I will now ask my sister, the Honorable Lady Justice Helen Obura, to address the court.
Thank you, my Lord. I stand on the protocol that was well laid out, and I wish to start by thanking the Almighty God for enabling us to gather in this court this day to honor our senior brother, Justice Fredick Egonda Ntende, for his distinguished service as he retires from active judicial service. I'm speaking on behalf of my sisters at the Court of Appeal. I'll start on a personal note. I knew Justice Egonda Ntende through his judgments when I was a state attorney in Attorney General's chambers long before I met him physically. One of his judgments, which has been referred to here a number of times, Osotrako Limited versus Uganda, shook our anchor as state attorneys in Attorney General's department. In that case, he held inter alia that Section 5.1 of the Government Proceedings Act that precludes court from granting an order of eviction against government must be read subject to the 1995 Constitution. Further, that Article 26 of the Constitution guarantees the right to property, and that Section 5.1 was not effective redress that court was enjoined to give under Article 5.1 of the Constitution. That decision caused serious mourning on the fateful day it was delivered. One of our colleagues, who is now a judge, who argued the case, returned to the department crestfallen and brought sad news to us. And we all gathered in the office of the Director of Civil Litigation as though we had received news of the death of a loved one. We immediately resolved that an appeal should be filed, and we were persuaded beyond reasonable doubt that the judge had got it wrong, and the Court of Appeal would definitely overturn the decision. To our shock and dismay, the Court of Appeal agreed with the learned justice, Egonda and Ntende, and upheld it. And that really caused us trouble. We always found provisions of the law that put some form of restrictions or conditions for suing government, a low-hanging fruit that we would leverage, because getting timely and proper instructions from government institutions was not easy. So we would always look out for plaintiffs' failure to comply with the mandatory requirements of the law and would capitalize on that to raise preliminary objections. And we were always lucky that the matters would be dismissed. My Lord Justice Egonda and Ntende, you disturbed that position. And you threw the state attorneys off guard. It was only later when I became a judge that I appreciated what you did. My Lord, working with you closely in this court, as you headed the panels where I sat with you, and as we interacted in the meetings of justices, gave me opportunity to know you better and to appreciate your mature, humane, and high sense of justice. That high sense of justice made you confidently venture into uncharted waters, which you grounded in the law and well-reasoned to stand the close scrutiny of appellate courts, and Osotrako was one of those judgments. My Lord, your kind heart made you look at criminal justice from the perspective of both the victim and the offender. Whenever we handled criminal matters together and we wanted a higher sentence, you would quickly remind us that even one day in prison is bad enough. And if sentencing is to serve the purpose of both retribution and rehabilitation, it does not have to be very long. The state of prisons also informed your decisions on sentence, because you also quite often reminded us that the capacities of our prisons were overstretched. My Lord Justice Egonda, your brief and concise judgments that addressed all relevant matters is admirable and commendable. I do not know how you do it. My effort to try and adopt your judgment writing style failed again and again, until I settled for my own style. My Lord, you also drafted and circulated your judgments without delay, and you always advocated for expeditious drafting and delivery of judgments after matters were heard. I would always see the pain in your heart whenever you talked about delayed judgments in our meetings. As I conclude my brief remarks, I wish to extend my deep appreciation to you, my Lord, for being a good role model to us. You interacted with us so freely, and whenever we consulted you, you willingly shared your wise viewpoint and wealth of experience with us. I also wish to add my voice in thanking your family, especially your wife, for walking this journey with you. We will surely miss you in the Court of Appeal. My Lord, may the good Lord whom you serve and whose principles informed your decisions richly bless and reward you with joy, perfect health, long life, and fulfillment in your retirement. We look forward to enjoying more fruits and honey from your farm. Thank you.
I thank the Honorable Lady Justice Helen Obura for her address to the court. And now the time we have all been waiting for, may I, with great humility, ask the Honorable Dr. Fredick Martin Stephen Egonda Ntende to respond to the addresses that have been made before this court. Thank you.
Thank you, my Lord. My Lords, members of the bar, my friends, my family that have come here today, I thank the Almighty, our Lord and God, who is the Alpha and Omega, for all his blessings on us all, and who has brought this day to come. For all the achievements and successes that this journey has witnessed, I give glory to the Almighty. And where I have fallen short along the way, I crave forgiveness. I thank my parents, Yonosan and Margaret Chudu, who sacrificed so much that I can have opportunities that I have had in this life. I thank the organizers of this event, my brothers and sisters on this court, your worships, and all other members of the staff of the judiciary who have in some way been part of this journey. I thank the members of the bar and this court who have spoken today for your kind words. I thank my family and friends who have been part of this journey and have supported me along the way in so many ways. Time does not allow me to single out each one of you. I will, though, single out two. Firstly, Dr. John Zabasajja, my childhood friend, and my deputy as head prefect Busoga College Muiri, who has traveled all the way from California, USA, to attend this event. Needless to say, he has traveled the most distance among all of us. Thank you for being here. Secondly, I wish to thank my wife, Margaret, for the wonderful support and heavy lifting that she has done on this journey. When I received an offer of being appointed a judge of the High Court in mid-1991, I discussed the matter with her. My inclination was to decline the offer on account of the very poor pay at the time, which meant that I had to suffer a cut in income from a successful and growing practice of law. She encouraged me to accept, despite the immediate consequences, agreeing that she would counter the adverse effects. Lo and behold, on accepting the offer, she answered an advert from UNICEF and a tolerable job offer was made to her. She accepted and henceforth became the provider in the family. Margaret introduced me to computer use in the early 90s. Of course, not just me, but all members of our family were too introduced to computer use when she bought a used 386 or 486 computer and established it at our home. As a result of this introduction, I too became a resource in the judiciary and an advocate for the adoption of information and communication technology. I would like to thank two special friends in the worldwide free access to the law fraternity, Kerry Anderson and Maria Badeva, initially of the South African Legal Information Institute, and later on, Africa Lee, whose invaluable and unwavering support, technical, logistical, and financial, gave birth to the Uganda Legal Information Institute, and later on to the Seychelles Legal Information Institute, that filled a void and transformed access to primary legal materials, the toolkit for the rule of law and administration of justice. Africa Lee continues to this day to support ULI, that has kept ULI as the premier provider of free access to the law of and in Uganda. I thank my senior brothers and sisters that I found on the bench, and those who joined me along the way for their support as I started and continued this journey, now drawing to an end. One particularly introduced me to an understanding of how the team judiciary, if I can use a sports analogy, operated. A couple of times I recall, when a colleague or two were elevated, he would chat with me and say, open quote, I talked to the chief, and he told me he did not want to weaken the High Court, so he had left me in position, close quote. As a result, I understood at the beginning of my tenure that as a member of Team Judiciary, you played the position assigned to you. It was up to the team manager, and at times there were more than one, by nature of the constitutional architecture of the judiciary, to assign you a position. From early on, I knew that my role was to play the assigned position, and that was all that mattered. I have been content. In soccer, a team member could be rested for one or several matches, or simply a part of the match. At times, he could be loaned to another club or sold outright, depending on the interests of the team, and I suppose the team member. I'm glad that during my journey, the team managers loaned me out to other teams elsewhere, allowing me to broaden my experience, professional development, and satisfaction. I thank the team managers of the team judiciary, who, in light of their reading of my strengths and weaknesses on the team, led me to claim the trophy for the longest-serving High Court judge in recent memory. Unfortunately for the Court of Appeal, one of my brothers has beaten me to this coveted prize. However, I come a close second as of today. I would like to thank the giants of our time, on whose shoulders I and others have been able to stand to serve the people of this country and beyond. I will bring out only two, given the time constraints. Talking of Justice Chitio, Chief Justice Wambuzi stated, and I quote, while at Buganda Road Court, he featured prominently as the Chief Magistrate, who refused to abide by Idi Amin's verbal orders to imprison miniskirt-wearing women without the option of a fine, which was permitted by law. He said rather undiplomatically, open quotes, that will remain idle talk until a law is made to that effect, close quotes. For those who knew Amin, this refusal was a heroic stand which could have cost him his life. He survived Amin's wrath. I commend Mr. Godfrey Ruled, the then Minister of Justice and Attorney General, who stood by the late judge in the latter's defense of the independence of the judiciary and the rule of law, close quotes. This was in 1973. The charge was being idle and disorderly. Chief Magistrate Kitio found it to be idle talk and did not hesitate to say so. If it was within my power, I would rename Buganda Road Courthouse the Kitio Courthouse in honor of this hero and titan of our time. It is just Kitio as a senior colleague who early on in my career schooled me about how the team judiciary operated that I referred to earlier in these remarks. The other titan featured in this story and has not put to print his own role is Chief Justice Wambuzi, probably due to his modesty and humility. When alerted by Mr. Ule of Amin's anger at Chief Magistrate Kitio, he asked Mr. Ule to set up a meeting with General Amin. He had not become Field Marshal by then, I suppose. Mr. Ule obliged. At that meeting, Chief Justice Wambuzi schooled Amin about the concept of separation of powers in government in a language that Amin could comprehend. He explained to him that Amin was both the executive and the legislature. He thus held 2/3 of the powers of government. The judiciary, which was the other part, was headed by the Chief Justice, and that it was up to the Chief Justice to discipline Kitio if he erred, and not Amin. He also advised Amin that if he wanted women imprisoned by wearing miniskirts, he had to make a law to that effect. This was subsequently done. In my view, in the foregoing story, it is not only just Kitio who emerges as a giant and a hero. So does Chief Justice Wambuzi, who took on the dangerous role of explaining to Amin that he was wrong regarding Chief Magistrate Kitio and should leave him alone. The wonder is that Amin did. If it were in my power, I would name the Supreme Court Tower the S.W.W. Wambuzi Tower in honor of his heroic defense of the rule of law and independence of the judiciary for over 3 decades. For my part, I pay tribute to these 2 giants for providing shoulders upon which I and others have stood on to serve the people of Uganda and elsewhere. Indeed, the present generation of all judicial officers, whatever the level or position, need look no further for worthy and inspiring examples to emulate. Multiple weeks ago, I read and viewed in both print and broadcast media the story of a couple of young children mourning and burying their mother who had passed on as a result of a lost battle with cancer. The children were grieving and burying their mother alone without their surviving parent. A father held on some minor, obscure, and yet unproven charge in a subordinate court. The charge did not involve loss of or threat to life, limb, property, or reputation. The father was held in pretrial custody, denied bail, long past the constitutionally permitted period for denial of liberty. What society treats its children like this? Without mentioning the persons caught up in such a criminal justice system. Team Judiciary, where are your Kitios and Wambuses at this hour? To the Team Judiciary, and indeed all of us present, I leave the following words of St. Paul. Therefore, my dear brothers and sisters, stand firm. Let nothing move you. Always give yourselves to the work of the Lord, because you know that your labor in the Lord is not in vain. Finally, brothers and sisters, whatever is true, whatever is noble, whatever is right, whatever is pure, whatever is lovely, whatever is admirable, if anything is excellent or praiseworthy, think about such things. Close quotes. Thank you all for coming today. I thank you for listening to me. God bless you all.
I thank our senior brother, the Honorable Justice Dr. Fredick Martin Stephen Egonda Ntende for his remarks. I thank you all for coming. So, my Lord's spiritual, my Lord's temporal, your worships, distinguished members of the bar, ladies and gentlemen, this valedictory proceedings has come to an end. It is a tradition which we will establish firmly in this court, so we hope to see you at our next one. As earlier ordered, these proceedings shall be transcribed and become a permanent record of the court. Hereinafter, we shall have photographs at the quadrangle, which is just outside the court, and the court shall be pleased if all of you here will join us on the 7th floor for lunch at 1 p.m. This is the end of these proceedings.